My name is Stephen Smith, and this is automobile subrogation in all 50 states, a view from 35,000 feet. It is 2 hours. We're going to do some questions at the end, so I got to leave a little time for that. I'm going to do my best with timing. There is a lot to go through. What this presentation is it's a pretty comprehensive overview of all kind of the issues at play in various states. Really what I want everyone to walk away from at the end of this presentation, I don't think anyone will memorize every law in all 50 states that we go over today. That's not realistic, but the idea is I hope as we go through the presentation you start to appreciate some of these issues and the questions you need to ask, because where a loss happens and how issues are treated are they're different in every state you go into. So we're going to go into more of that. One thing I wanted to mention right at the onset is I hope to do more of these, and I want to do presentations that you all care about, that would be helpful to you. So with that in mind, what we're thinking of doing is breaking down some of the more complex states, or some of the more the states that have maybe more nuanced issues going on that another webinar would be helpful on. So what I was hoping you all would do was in the questions tab, if you could, and you don't need it right now, just think about it as we go through the presentation, put in there a state that you'd like to see another presentation about, and we'll go through some of the, like I said, a few of the states in separate presentations in more detail. And with that, we'll get going. So why is automobile subrogation critical? Well, the stats show it. The National Highway Traffic Administration, you see that the fatalities went up in 2020 about 10.5%. That's from the BI's part of things. On the collision and property damage side of things, we have other issues going on. We have 32 million parts being recalled. What does that mean? Well, it means something both on recovering on collision damages and potentially liability. Recalled parts, have to do with a lot of automobile claims and accidents where there might be product liability at play. You see the stat right there from the Center of Disease Control, about $55 billion in medical and work loss costs in 2018. The point here is there's a lot of money. There's a lot of money at stake, and figuring out how to best recover what's been paid out is going to help recoup some of these large sums that get paid out on these claims. So when you hear about automobile subrogation, the main one line of coverage we're talking about is a personal automobile coverage, and it has what is fairly typical. There's a bodily injury part of it, some property, and then they have, there's limits per person, per accident, uninsured coverage. In this personal automobile coverage, and here we already start noting some differences depending on where you are. There's usually medical payment coverage, and that's for what you think it would be for: hospital bills, stuff that has to do with personal injury. And then right below it, you see personal injury protection. That deals with a lot of the same stuff in medical payments. The difference here is that medical payments in a lot of jurisdictions are voluntary. The insured has the option to prove that line of, to purchase that line of coverage or reject it when it comes to their first party coverage, meaning it's paid out regardless of fault. Personal injury protection is the same thing, but it usually applies in a no fault state, and then it can cover a lot of the things that medical payments do, but it can also cover lost wages and stuff like that, depending on the jurisdiction you're in. It's also uninsured and underinsured motorist coverage. That's probably the thing where I touch on the least in this presentation, but if it's one of the topics that people want to hear more about, we can do, like I said, another presentation on it. And then you have the collision coverage, the damage to the vehicle involved in the accident. So those are generally the categories. Yeah, so you know, you have commercial auto coverage that has the different types of lines, and those policies are hired versus non-owned coverage. And what we're getting at there is whether there's been it's usually a motor carrier situation where you have independent contractors involved and their tractor trailers being involved. Commercial policies are also issued to garages that do mechanical work for good reason. Stuff can happen within the garage that could, unrelated to the vehicle, that could consume it, like a garage fire, something like that. And that's the garage keeper's liability coverage. So you have personal and commercial auto. Those are the two main types of coverage we have that way. Now, aside from having personal and commercial, the other big difference that's going to be at play throughout this presentation is no fault versus traditional tort states. And what I mean by that is, in a traditional tort state, recovery is usually found by what you think of as a typical tort. Was the other driver negligent, and was that negligence a proximate cause of the loss at issue for which benefits were paid? No fault insurance is different, and the reason why is because under a no fault regime, benefits are going to be paid regardless of who's at fault. And I mean, as the title says, the no fault. So the first inquiry perhaps is not always a matter of tort when you're looking for recovery. Instead, it can be priority. And so this is where personal injury protection benefits are paid. When it comes to the amount that are paid, usually there's a statutory threshold that has to be met. Michigan is a classic example for everyone out there that does Michigan. I do a fair deal of it. It's one of the most complicated statutory schemes you'll see. And they just revamped it back in 2019 and 2020. But there are thresholds now on what needs to be paid out. It used to be unlimited medical. Now the insured, depending on their situation, can choose different thresholds of coverage they can get along the way. In these no-fault states, and I'll stick on Michigan because that's, like I said, the most complicated and the one that usually has the most questions. There is a limited avenue for tort recovery, and it's found right in the statute. And generally speaking, Michigan, for example, there's tort recovery for economic damages if you have either an out-of-state accident, an uninsured vehicle, or an intentional act. And there are also different tort thresholds for whether you can recover non-economic damages. And so a totally different threshold is at play there, which looks to the nature of the injury. Was it permanent? Was there death? Was it serious disfigurement? So these are a couple things that are at play with no fault that perhaps you're not looking for in a traditional tort state. And then there's modified no fault, where there's a little bit of both going on. Minnesota has some of this. For example, with a commercial vehicle, there's a transfer of loss to another insurer who issued a policy to another commercial vehicle holder if it's involved in the accident, and then you can do arbitration. That relies on tort to a certain degree because the commercial vehicle involved in the accident needs to be at fault for the loss as we traditionally think about it. But the mechanism to go against and do that type of recovery is different. For example, you can only go against the insurer in Michigan, and you have to do arbitration. It's mandated right by the statute. Or excuse me, in Minnesota, I apologize. Minnesota, you have to do arbitration against the commercial vehicle holder directly by arbitration. I mixed that up. What I was in the back of my mind, I was also thinking there's also mini tort in Michigan, which also looks to fault of the driver, again, a modification of the no-fault scheme, and then has to deal with property damage benefits. So that was, like I said, an overview of kind of the different schemes involved. Let's get into the general subrogation part in a traditional non-no-fault state. So what are we looking at first? We're looking at the contractual language in the policy. And really, this is because you can have three different types of subrogation, and they're up on the screen there. You can have contractual, equitable, and statutory. Statutory is usually the strongest rights you have because there's no ifs, ands, or buts about it. You know, it's written in the statute. Well, I should give the caveat, assuming the statute is clear, but that's probably the strongest language. The second one on the top there is contractual subrogation. What are we looking towards? We're looking towards the policy to make sure it has that language in the policy. Something akin to, if you're involved in a loss, we have a right to pursue third parties who are liable for loss, something like that. So you're looking towards the policy itself, or perhaps a subrogation agreement or assignment, something like that. In the equitable subrogation side of things, this is, a lot of states do recognize equitable subrogation. There are some that don't, but a lot of them do. If these states tend to involve other equitable arguments, like the made whole doctrine, for example, which says the insured needs to be fully compensated for his or her loss before the insurer can subrogate or be reimbursed from a recovery. And you also, common fund doctrine is another one where the person who procured the recovery is sometimes entitled to some attorney fees and costs for procuring the recovery. So those are kind of the three different veins of traditional subrogation. You're either looking at the statute, the contract, or equitable principles. We touched on this before, or I gave a little one before, but that's typical subrogation language you'd see in a policy. If we make a payment under the policy, and the person has a right to recover damages from another, we're going to be subrogated to that right. And then you see it in subsection B. That's really a kind of belt and suspenders provision, I think, anyway, because it says if we make a payment under the policy and the insured recovers, they're going to hold that money in trust, and they're going to reimburse us in accordance with the recovery and what was paid out on the claim. So A, I kind of see as a right of subrogation. B, I see as a right of reimbursement. And I think both are very good clauses to have. They help, cement the rights that you're trying to seek. So how can you resolve a subrogation interest? Well, there's a lot of different ways to do it, and there's a lot of different ways to protect those rights. An insured very well may settle with the third party. What's going on here is there could be things that haven't totally been adjudicated in the court yet. For example, up there I have the made whole issue. So if a case goes to trial, it's somewhat easier to show whether the insured was made whole or not, because what do you have? You have a resulting jury verdict that found damages. And depending on what it says, you can perhaps glean whether an insured was made whole from there or not. When you settle either before trial or before even litigation, some of these made whole issues get a little harder because there isn't as much out there to show what the total amount of damages the insured could recover on that should go towards a made whole argument. And we're going to go more into made whole in a second, but so that's one avenue where a settlement can happen. They can also be resolved at arbitration. This can go a couple different ways. It can be arbitration from, like I went through before, some states mandate arbitration when it comes to recovery. It can also be arbitration that the insured is involved in. Maybe it's some sort of dispute with another entity where there's a mandatory arbitration clause. If the insured has not filed suit or settled or gone to arbitration, one of these recovery methods, there's also the idea of filing a subrogation suit. We do that often. The advantages of it are we're driving the boat on the claim, and we're for sure in the loop on everything that's going on because we're the ones primarily prosecuting the case. When you're deciding whether this is the best avenue for subrogation, it really needs to be a decision that's thought out. Oftentimes there's a reason why the insured has not taken another path to recovery. And sometimes it's a very genuine reason. They're not money hungry, they're not grabbing for a check, anything like that. In some cases, that's the best thing because you have a very likable insured that you're trying to recover benefits you paid out to him or her. So it's a good thing. But other times it's because maybe something was left off the accident report, or liability is not as great as it appears on paper. So the point is when deciding whether to file a subrogation suit to recover on the benefits paid, there's a few issues at play that need to be discussed. When it comes to if the insured has filed suit, what you can also do is intervene. You can get in the middle of that process and insert your interest. What are the advantages of this? I think there are a few of them. First one is you're in the loop again on what's going on in the court proceeding. If you've successfully intervened, you should be on all notices of proceedings going forward, and that includes discovery. I'll tie that back into the made whole issue. Like I was talking about before, this often comes up down the road where made whole is at issue. It's normally at the tail end of things because the claimant's counsel attorney is arguing his or her client was not made whole by the settlement. And if you've intervened and you've been along the ride, for lack of a better term, and seen everything that's come out into discovery, all the provider debts, all the bills, everything defense has said, for and against reasonableness and relatedness of treatment, you have some ammunition to perhaps combat that made whole argument that's coming down the road. Without being involved, you're kind of at the mercy of relying on others for information. Plaintiff's counsel may tell, they have, X amount of damages. If you weren't involved in the discovery, I guess you can request it from him, but you're going to get what they want to show you, as opposed to after you've intervened, you get a lot more. Again, this is a cost-benefit thing. On the particular claim, intervention could be the best call. Filing a subrogation suit could be the best call. There are a lot of different ways to secure a recovery, and it really depends on the issues involved and kind of a cost effectiveness analysis. Moving on to Medpay and PIP, and I kind of went over this before, so I'll go fast here. Medical payments, medical insurance, medical expenses of the insured and passenger, regardless of fault. PIP payments, like I said, kind of the same thing. They're at play in the no fault states, and there's a list of them there. And you see Michigan and Minnesota on there, and it's often associated with these no fault regimes. Some states provide for MedPay benefits, but not PIP, and vice versa. And that's like, depending on the scheme in place, are they a no fault state or not? As far as the MedPay subrogation, now going into a traditional MedPay non-no fault state a little closer, there are some states that only allow reimbursement. So California, for example, has case law saying an insurer that paid first-party benefits is allowed to be reimbursed from a recovery obtained from a third party, but they're not allowed to subrogate from it. So what do you need? You need the insured to be driving the boat. In other states, you actually need to have the subrogation language in the policy. So on that slide we were talking about before was statutory, equitable, and contractual subrogation. What we're talking about here in states like Alabama, Illinois, and Louisiana is you got to make sure in the policy it has that language or similar language to what we looked at before, saying if we pay benefits, we have the right to go after those who caused the underlying loss. In states, depending on your jurisdiction, Alabama, Illinois, Louisiana, you're going to want to look for that language in the policy. In some states, you can't do direct subrogation at all. Arizona is one of them. And in other states, the right to bring a subrogation claim is in doubt, and California is one of those. There are other states that we can do different, maybe it'll come up in the questions. Washington, Missouri, there are a couple of states that have some really changing law right now on the landscape of subrogation. And some states only allow subrogation if the statute provides for it. And I have Connecticut there, but I'll also go over the DC one because I think it's worth looking at. So the point here is that slide we went to before, conventional, contractual, or statutory, that matters depending on the jurisdiction you're in. And if you're in a state that requires subrogation language and you don't have that language in your policy, subrogation recovery is going to be problematic. I said I'd look into the DC statute, and here it is. This has to deal with subrogation on a traditional Medpay, and the highlighting is my handiwork. For me, it's how I keep it straight on what this thick language means. But you can see the statute in some of these cases dictates the subrogation right, and it also tells you what rights you have that are a little different than other states. So in DC, for example, you see this first sentence here: unless the subrogee files a petition to intervene and is independently represented by counsel, and then I skip ahead here, the amount that you're allowed to recover from the third-party recovery, and you see it has this formula in here, and it, divided by the total amount of cost of litigation, blah, blah, blah. I won't read it all in. So when you divvy that down, and I just did this by way of illustration, I'll go fast because I can't go through it all that quickly. You see you have the statute gives you this formula for attorney fees plus costs over a third of the recovery times subrogation amount equals the amount of the lien reduction, but you can't pay over 1/3 of the total recovery. My point with going through all this is if you're savvy and you know some of these questions to ask, oh, DC has a statute on subrogation. I'm not saying you need to remember it all, but you can use these statutes to your advantage to know the landscape and protect your rights to the fullest extent. And what I mean here is that first sentence I looked at the beginning: unless the subrogee files a petition to intervene in a personal injury action and is independently represented by counsel. So everything that follows after that is the reduction. My take on it is if you intervene, you're not subject to this reduction. So when you're going through those questions we talked about before, when you're talking about, well, what's the best way to protect and enforce our subrogation rights? Is it a settlement? Is it intervening, filing our own subrogation suit? If you have a District of Columbia accident at play, the right answer might be intervention, because it gets around this reduction because you're looking to the statute for what the rights are. I'm trying to see how I'm doing on time. No fault, we talked about this already a little bit. There's no state that you can't sue for fault in any way, shape, or form. A lot of the no fault states, in some ways, recovery in the traditional tort sense is altogether precluded, like we went over before. There's thresholds, but the other thing to to be aware of in no fault is recovery can also come through priority and through loss transfer. And with the loss transfer, we're not looking towards which company, or excuse me, which person or entity should be liable in tort. We're saying which person or entity should be liable as a matter of priority, and that's usually set out through the statute. It is set out through the statute. State, what kind of subrogation are you looking for? You have a lien on the recovery, which gives reimbursement rights, and sometimes you have a credit. And by credit, what I mean is sometimes the claim is not completely closed. There's still benefits anticipated in the future. I'm just making this up off the cuff, but assume a $100,000 settlement. There's a lien out there of $50,000. Let's say, taking away all the other X factors, let's just say that lien gets paid out in $50,000. The claimant got another, they netted a $50,000 gross recovery. In some states, that can operate as a credit. So those future benefits on an open claim, you may not have to pay until the credit is exhausted. In other states, there's reimbursement rights against the third-party carrier only, meaning you can't go after the individual driver. You have to go after the carrier issuing the automobile liability policy. In DC, we went over part of the statute, but there's more in it. You can only have reimbursement if there's a non-passenger vehicle, or excuse me, if one non-passenger vehicle is involved. Then you have states like Iowa that have no limitations. All of these, I'll call them tools of recovery, are available to you. Looking at some of the, I'm trying to pick the best ones to go over here quickly because I'm running a little bit behind. Looking at some of the no fault nuances, and I'll go down there, the Michigan one, just to go quickly. There are other ways to subrogate that are outside of the purview of the limitations on no fault. For example, Michigan has a reasonably parked vehicle exception, saying that, hey, traditionally in Michigan, the question is, does the accident involve the use, operation, or maintenance of a motor vehicle? Well, if on a traditional roadway, if another driver leans into a parked vehicle, that does involve the use, operation, or maintenance of a motor vehicle. Whether there's subrogation rights and all that may depend on the car involved. So if it's a reasonably parked vehicle, the accident may involve a vehicle as required by Michigan no fault, but that's an exception to the limitations on no fault. So there might be recovery potential is, I guess, the point here. Building, same way, that can also be an interesting question. What happens when your accident is on a roadway, but it involves damage to real property? Perhaps they run into a lot and crash into a building. Will no fault protect liability in that circumstance? That's a very complex question under Michigan law, but it's something that changes the dynamic of where recovery potential exists. Intercompany arbitration, going at New York, that's a popular one as well. If you have a vehicle over 6,500 pounds, your avenue for recovery is going to be arbitration. The same can be said of Minnesota, and I went over that a little bit before. But in Minnesota, you'd also be going to arbitration if one of the vehicles involved is over 6,500 pounds and that vehicle was at fault for the loss. And your arbitration is against the liability insurer for the commercial vehicle owner, or if they're self-insured themselves. But the point here is depending on the jurisdiction, what you can do and how you can do it is going to change drastically. And I guess it really depends on, I said, the jurisdiction, but also what kind of damages are at play. So these are all questions that are important to ask. Uninsured and underinsured motorist coverage. Most states allow this. There's in a lot of states it's covered by statute directly, so you're looking to statutory subrogation. There's some consent to settle clauses, and what that means is the insured basically needs to get the blessing of the insurer to settle with the third party driver who's either uninsured or underinsured. And the point here is that the insurer paying benefits should have some right to say in the settlement, especially when the insured is claiming an uninsured or underinsured status, on the amount and whether their subrogation rights are pursued for damages outside of that settlement. The other thing that's somewhat typical in this situation is that the insurer can substitute their payments for that which would be paid by the third party or their insured in an underinsured situation, liability insurer that is. And the point here is the same. It's to protect the subrogation rights of the insurer paying out the UM or UIM proceeds. And so what happens is the insurer basically substitutes their payments for that which would otherwise be paid. And as a result of that substitution, they now have the right to pursue the third party driver who is either uninsured or underinsured. Collision subrogation, this deals with damage to the vehicle. This is usually collision is not found in statute. It can be in some states, but for the most part, it's not. The reason why is collision coverage is usually an optionary type of coverage extended to the driver, and it can be even in a no-fault state or a regular non-no-fault state. This is I talked on it before, but Michigan has a mini tort part for collision damages, which allows a limited tort recovery. It used to be $1,000, now it's $3,000 after those statutory amendments I talked about back in 2019 and 20. But that's one of the rare, I guess, one of the outliers in that your avenue for collision subrogation is going to be found purely in statute. And the point of it is to recover the deductible. In fact, the Michigan mini tort has a caveat in it. It's very thick. We get a lot of questions on it because it's overly complex for no good reason, but it allows recovery of benefits to the extent not covered by insurance. So what are we talking about there? We're talking about the deductible of the insured. But if you're not dealing with Michigan and maybe a couple handful of wonky states like that, what you're looking for is what you would traditionally look for in a negligence claim, damages paid out and negligence on the other side. Now this lends itself to a very good question of what are the damages we can recover for when we're talking about collision subrogation. There are a lot of different ways to calculate really the same question. In some states, what you're talking about is the difference in the market value before and after the accident. That's, I guess, one of the more prevalent and straightforward ways to go about it. You're just saying, what was the car worth now and what would it be worth after the accident? A couple things to keep in mind when you're doing it this way. One is, and perhaps this is lessening, maybe it is, I don't know, we'll see how things turned out. But market value before and after, that took quite the shift during COVID. And with some of the parts that were on back order, those valuations were maybe a little bit higher, especially a year and a half ago when some of these vehicles were hitting all-time high prices because of the back order. So that's one thing that can be very situational. And you also had, reasonable cost of repair only. No states do that. Whichever is lower, there's a couple that do that. So it's either cost of repair or difference in the fair market value. You have a couple that take The lower of the two, Maryland, North Dakota. There's a bunch of them in here, but so you see the repair cost plus diminution of value after repair. So what we're talking about there is some states allow you to get the repair cost, but after the vehicle is repaired, there's a lot of stuff. You have perhaps aftermarket parts. You have something coming up on a Carfax report saying this vehicle has been in an accident. That inherently diminishes the value of any automobile. If anyone's going to buy a used car and they see an accident, it's more likely going to be worth less than the same exact car, mileage and everything that doesn't have that appearing on the report. So there are some states that allow you to get that as well, the repair plus the diminution of value. And then if you can't repair it, the cost of repair, loss of fair market value. If you can't restore it, there's a couple like that. If you can't get back that diminution of value is what we're talking about there. There are some states where you get the plaintiff gets to pick which one they want more. Of course, they're going to pick the highest one or the one they have evidence on, but assuming they have evidence on both of them, the highest one. And some, Washington depends on was it a total loss or not. If it's not a total loss, you're going to go by repair cost. If it was a total loss, you're going to go by fair market value. And then Ohio down here, I put that in as well to say, well, you also have a situation where you have the difference in fair market value before and after. There might also be a salvage recovery depending on the vehicle involved. So that also needs to be taken into consideration. Some of the other damages we're talking about when you're talking about collision, proving up damages, I was talking about this a second ago, whether you have evidence on it. If you're going to talk about the fair market value, usually a person who purchased the vehicle can talk about what they paid for it, what they'd have to go out on the market and buy the same car for. There can be testimony there. Repairs, usually you're going to need something from a shop or a mechanic or someone. It's going to prove the cost of repairs. You're going to want something more official, I guess, for lack of a better term, on objective evidence to put out there. The other type of damage you can get in collision subrogation is loss of use. Loss of use, it depends a lot on the state and how much you can. For example, you see there in Iowa, you can't have the cost of repair plus the loss of use exceed the fair market value. Again, this may be a situation this could be a very situational question, and COVID and all that came with it. Like you look at like a state like Iowa, it seems like, well, how are you going to have repair plus loss of use to overtake the fair market value in total? Well, yeah, I could see that happen if a garage is closed for a very long time, or the part they need is on back order for a very long time. You could get over the fair market value that way, and in a state like Iowa, that's something to be cognizant of. When we're talking about what damage is owed, you have replacement value versus actual cash value. I'm sure most people have dealt with this, but fair market value over what would it cost to put them in a car today, and basically not have depreciation. And that not have depreciation as replacement for actual cash value is fair market value. You can look to Kelley Blue Book. Everyone's got appraiser reports, stuff like that, and anything to show what the fair market value would be. There are some states that do not allow collision damages separately and apart from other damages. Missouri, I talked about it before, is one of perhaps the more troublesome states, but you can for property. There's some prohibitions and limitations on personal injury subrogation, but that's a state where the type of damages at issue is going to dictate what can be recovered. Another nuance in all these states, in whatever jurisdiction you're going to want to pay attention for, is the made whole doctrine. Generally speaking, it's when there's not enough money to go around. So the claimant has $100,000 in damages, and let's just say the recovery from the tortfeasor was only $50,000 for whatever end. The argument would be the claimant is not wholly compensated because they're $50,000 in the red. So that's generally what the made whole doctrine is. Why is it important? Because this is yet another thing that differs state by state. So some questions you want to ask are, does it even apply? We'll go into this. It's the third point down there. Can it be overwritten by policy terms? In some states, the made whole doctrine can be overwritten by policy language that expressly disclaims it. So that, I guess that's kind of your first question. Does the doctrine apply? You want to look at, one, are we in a state that recognizes the made whole doctrine? And if they do, what are some of the exceptions to it? And can a policy override made whole? Another question is, when is an insured made whole? And there's a couple states that this question too is different, because if let's just say an insured has 50,000 in medical damage and 50,000 in and let's just call it pain and suffering and some of those non-economic damages, are they made whole? Well, in some states, when it comes to made whole for the purposes of subrogation, you're going to look toward the type of benefit paid. And if there's no distinguishing, or if the jurisdiction allows you to distinguish between the type of benefit paid, you're just going to compare the amount of their, let's just call it medical damages, to the amount of medical damages paid, and that's the inquiry. If it's a different state where it's a comprehensive look at it, you're going to look at medical and some of those pain and suffering damages, all that to decide whether they're made whole. The other thing that can be at play here is, do you count the insurance benefits that were paid? So if the claimant, like I said, had 50,000 in damage and the tortfeasor had 50,000 recovery, somehow that was secured, and the insurer claiming subrogation paid 50,000, well, the claimant in that situation got 100,000, even though only 50,000 came from the tortfeasor. So can you include those insurance benefits in the made whole equation? And you see that on the second to last point, property loss versus bodily injury and economic. Another thing to ask is whether the insurance attorney fees should be included. And I'll go over all these questions more in depth on specific states, but again, I got to go quick, but we can talk about them. Like I said, if there's a state in particular that people want to put in the ask a question, I'd be happy to go through them. But does the made whole doctrine apply? You see, I'll take a couple of them. In Mississippi, yes, you have to have all damages recovered for before subrogation is allowed. So you need medical, pain and suffering, all of it. You got to get above that amount before subrogations are allowed. In a state like North Dakota, no, you're not even looking towards the made whole doctrine because it doesn't apply. In Massachusetts, it does not apply, but you have to show that the benefits you paid were like benefits. So that's kind of an interesting, it's not made whole per se, but it's an interesting inquiry because on one hand, benefits may have been paid out to an insured for a certain line of damages. Let's just say chiropractic care. And if that's not being included in the recovery, maybe the claim is just going after pain and suffering or something, then it's not the same element of damages. So kind of a different, not made whole on the nose, but kind of the same vein of thought. So as you can see, it changes a lot depending on the state. When is the insured made whole? Same thing I talked about before. In a state like Tennessee, you have to have all the damages. You got to put them in there. In a state like Washington, this is, you have, this is kind of an interplay between a couple different issues, right? If the insured settles for less than the policy limits, the only made whole only applies for elements of damages paid by the insurance. So this is where you're divvying it out. You're going pain and suffering or medical, and talking about which one made whole applies to. And when I said this is a intersection of a couple issues, because on one hand we're talking about the made whole doctrine, but on the other hand, we're talking about what type of recovery are we talking about? Are we talking about a jury verdict, a settlement, arbitration, etc.? So again, these are questions that are good to ask to know what the strength of recovery rights are. Can made whole be negated by policy terms? It can be in a lot of states, and I list a few out there that allow it. And we already went through the language. It's good to have both subrogation and reimbursement language in there, but some simple subrogation language that's not overly ambiguous or convoluted. A simple subrogation language is usually sufficient to overcome made whole. If you want to avoid the made whole doctrine, which is to the benefit of a larger recovery, so I think most do. The starting point is the policy language. Like we looked back before, a lot of states do allow policies to disclaim made whole directly. I talked about this before, but intervening to be in the loop on what damages are being claimed, what are part of the settlement, make sure nothing's being gerrymandered into one element of damages or another, can be a good way. If you're participating in the case, you can also do this through jury instructions and questions that the jurors need to answer to make it clear after any resulting judgment what amount was paid. And if it's a state where you're looking at the damages at issue, instead of if you've intervened, if the carrier's intervened, and usually the insured is driving the boat, but one question that could perhaps get asked is, instead of saying, what's the full amount to reasonably compensate, Joe driver for this accident? The jury instruction, you can push for a jury instruction. What's their reasonable amount of medical? What's the reasonable amount of wage loss, pain and suffering, etc.? The point is that by participating, you can ask some of these questions to get ahead of made whole, because in some situations it's going to be an issue down the line, and usually the fact that it's going to be an issue has already been tipped if we're talking about going to trial, because you've already been usually through some sort of ADR, mediation, arbitration, something like that, where someone's argued made whole. And then I guess the other one is look at the policy limits and the settlement amount. In some jurisdictions, if the insured is going to settle for less than the policy limits, then that's either a presumption that made whole will not apply, or it's a prohibition on made whole. And the rationale to me makes sense anyway. It's, well, you chose not to be made whole by settling for less than the value of your claim. So that's another thing we want to be looking at when we're trying to negate the made whole doctrine. Another one of these doctrines that vary by state, and it's very important because it's going to change the landscape of recovery, the common fund doctrine. And this just says a litigant who creates or preserves the fund is entitled to recover litigation costs and attorney fees from creating the fund. And the idea here is to prevent, I guess, a free ride, or in legalese, unjust enrichment. It's if the insured is going to go out and prosecute this claim, then the resources they spent in doing so should be reimbursed to the extent the insurer claiming subrogation or reimbursement benefited from those resources. It depends, again, on state by state, and these issues again can intertwine with each other to create even more unique and interesting questions. So does the made whole doctrine apply? That's going to affect the amount of the recovery and in turn application of the common fund doctrine. Proportion of attorney fees and costs. In some states, this is established. There's a cap on it. In a lot of states, it's what's reasonable under the circumstances and in the given jurisdiction. What happens, another good question is, what happens if the carrier assists in affecting the recovery? So perhaps both the carrier and the claimant have been involved in the litigation. Maybe the carrier claiming subrogation got some sort of accident reconstructionist or did something along the lines to assist with securing that recovery. Should common fund apply in those situations? That depends on the state. Can it be avoided? That is another good question, and it depends on, you're going to look at the policy language in some states. Can you get around it by looking at the policy language? And maybe some of these other issues, application of made whole, etc. Does the carrier or plaintiff's counsel for that matter need notice? And this is to tell the carrier or whoever is benefiting from the common fund, do they need to have notice of what's going to be charged for the common fund and what the settlement was and all that? I already went over the made whole, same element of damages. And again, are you cutting out the attorney fees and then calculating the common fund, or are you doing it based on the gross recovery? That depends on states. So again, on all these questions, I have state specific examples to show this differs by state, and you need, depending on what state you're in, the answer could be drastically different. In Mississippi, they haven't yet to apply it to auto subrogation. In Iowa, yeah, you see there by statute, it requires a pro rata contribution. And the same is true in Indiana. You're going to look at the statute and Arkansas for that matter, to say whether how do you actually calculate the common fund doctrine? And I have different states here. Maryland, for example, you divide the total recovery fees and multiply it by the total subrogation interest. It's usually a pro rata calculation that you're doing. It's basically taking the recovered subrogation interest against the whole recovery. In a lot of jurisdictions, you take that ratio and then apply it to the costs. So fees and costs. So it depends on where you're at. Certain states have standards that are allowed for common fund. Minnesota, for example, 20 to 30% is pretty standard, but there is no hard and fast rule. Can it be avoided? And these are some of the things we talked about before, but now you see the specific states. If you settle with the adverse directly, yeah, there's no common fund in Arkansas, and that makes sense to me because you're not benefiting. You didn't get the fund that you're recovering from someone else. You're doing it yourself. In Florida's underwent a lot of changes. We actually did a webinar on that a couple weeks ago that I think will go live shortly. I encourage you to check it out because Florida's underwent a lot of stuff. But yeah, if there's substantial assistance by the carrier, it can be avoided. Same thing in Illinois to an extent. Maryland, you see that, and participation, and if you intervene and are represented in the action, kind of like we saw in that DC statute before. So it can be avoided depending on the jurisdiction. These, again, are something you want to look out for is, can you avoid it by intervening, by substantially assisting, by your policy language? These are all good questions to ask. must notice be given. So for the common fund question to even be an issue, does there have to be some type of condition precedent that notice be given? And again, it depends on the jurisdiction. In Idaho, if there's no notice given, then you can't do fees and costs off. You can't take a common fund reduction. And you see that in Louisiana, Tennessee, and in Vermont, they have a kind of an interesting situation. You have to, if there was no notice, you go to the trial court and basically say, was the settlement reasonable, and is the lack of notice prejudicial? So the mechanism for getting around made whole, or excuse me, common fund, if notice was not given, can change on the jurisdiction as well. How to get around the common fund doctrine? Well, if you're in a state where it says participate or assist with garnering the recovery, a demand out for subrogation can bolster that position. It shows right off the bat, you know, you weren't just sitting on your hands waiting to see if someone else, if the injured claimant would go out and prosecute it. You right away, you know, you sent out a demand for subrogation. So that can show that, you know, it wasn't because of the insured's efforts alone. We did some stuff here too. Another way is like a property or a preservation of evidence letter. If we're sending out a letter like that and it's telling the other side preserve evidence, that can be useful down the line. In states where you can negotiate the claim directly, to avoid it, that's something you can do. You can get subrogation counsel involved on an hourly basis. The reason we have hourly in here is this can, and depending on the jurisdiction, but it can sometimes be offset against what would otherwise be owed in the common fund. The reason why is because, again, the insurer is not claiming a free ride here. They're getting counsel involved, they're engaging in the process, and they can show, well, you had, you know, X amount of time, and so we had Y. We had to do something to get our recovery, not just, again, sit on our hands and wait for a check. Keep records of plaintiff's counsel's efforts to destroy the lien. This is a good one because the argument in some jurisdictions you can make is, well, it wasn't their efforts were to assist in our subrogation recovery. In fact, they did quite the opposite and tried to take affirmative steps to negate or avoid anything like that, get around the lien. So documenting that can be helpful when you're trying to make an argument against the common fund doctrine. If the plaintiff's attorney represents you, you can waive your fee to try to waive the attorney fee to try to defeat the interest. I don't know. If there are situations where having the insured's attorney represent you may be the most cost-effective approach. I'm not going to say there's not, but hopefully you can see with common fund and these state-specific inquiries, is it statutory, is it contractual, and made whole doctrine, there's inherent problems there that if the attorney representing the insured is representing both claims or says they will, who are they really looking out for? It's hard to do both if some of these equitable doctrines are at play. The limitations period, I'll go quickly over this. You know, normally the statute you're looking for because you're stepping into the shoes of the driver involved in the accident, so you're going to look towards the insured, the claimant's limitations period, which is usually the date of the accident. That's most states. Runs from the date the cause of action accrues. I'm looking at that second bullet point in the second section. Maryland, for example. So what I mean there is a subrogation right, you know, it technically accrues when you paid benefits. If you haven't paid benefits, there's nothing to subrogate from. So and perhaps in some states it's when the cause of action accrues, meaning the underlying loss plus the payment of benefits. So maybe you're looking a little bit further out from the date of accident. Honestly, for best practices, everything involved, use the date of the accident. You know, if you're wrong and it's when the cause of action accrues, there's nothing wrong. You know, you can never unring the bell the other way. So while there may be variances where the limitations period is extended, follow the date of accident, I guess, is what I do anyway, and what I think the best practices are. And then, you know, there's some other special cases when the final payment is due in Hawaii and Kentucky. The SOL for breach of contract, that's an interesting question, because the reason I put that in here is when we're talking about limitations period, depending on your jurisdiction again, because some allow for subrogation and others allow only for reimbursement. When you're talking about reimbursement, you might have a different limitations period because you're talking about the insured violating the underlying policy, the policy that has that language. If you receive a recovery, you need to reimburse us. So the limitations period there, when you're talking about that right of reimbursement, could be the policy, which usually is a breach of contract, and in most jurisdictions is a longer limitations period than the underlying tort. And differing, and that's the last point, the differing statute of limitations for subrogation versus reimbursement, New Mexico. That's precisely the point I'm trying to make there. The other thing we want to be cognizant of is where we're at in the posture of the case and the claim, really, I guess. If the insured has already executed a release with the tortfeasor, there are questions that need to get going right away. So if you're talking about the third party and their insurer, can they still be liable for subrogation even though they have this release in their hand from the claimant saying, I release all claims, damages, etc.? And, you know, it's kind of an interesting question because, again, subrogation at its most simple step is stepping into the shoes of an insured. Well, if the insured waived all the rights against the third party, stepping into those shoes doesn't really help. What we want to be looking for here is, did the tortfeasor, their insurer, the person signing the release, or I guess the person or entity who the release is in favor of, better said, were they on notice of the subrogation interest before they signed it? Because if they were, in a lot of states, you can still pursue subrogation as though the release never came into being. And this is a very jurisdictional question. In some states, you can say the release and the whole settlement needs to get tossed out. In other states, you can say, well, that's fine that you did that and had this release, but you're still liable, at least to the extent of our subrogation payments. This can be the case even if there's been payments on the claim. So this happens from time to time where maybe a claimant's attorney is trying to pull a fast one or avoid subrogation and reimbursement recovery. So what they do is they try to make it lightning fast, get the settlement done right away before any payment is made. Well, yeah, I guess at the time the liability insurer didn't have notice of a subrogation claim because, again, payments hadn't been made yet. But if there's notice of a potential claim, that still might be enough for when those future benefits are paid to get around that release. What constitutes a proper notice of the lien or right, subrogation right, depends on the jurisdiction. In some states, it can't be waived by the insured in any way, shape, or form for PIP benefits, looking at New Jersey and North Dakota. Some states have specific notice that's required, Ohio. And then in other states, and this is what we talked about a slide ago, you know, you really need to think about these rights differently because it matters depending on where you are. The fact that there was a release with the tortfeasor, you might, in this situation, have two different avenues of recovery. One is a subro right against the tortfeasor. Again, hey, tortfeasor, you had notice of our subrogation interest, and then you entered into this settlement, which not including us. So we can still pursue you. You can do that on one hand, and then depending on the jurisdiction, on the other hand, go back to the insured and say, listen, our policy requires you provide, well, usually notice of settlement, or sometimes there's a consent to settle clause, something like that. That didn't happen here. You also have an obligation of reimbursement. We went over that on one of the first slides, that second prong of the language. And it's telling you can tell, well, of what you recovered, that needs to be paid back. So this is where we're pursuing reimbursement rights on one hand and subrogation rights on the other to maximize recovery. And which string to pull and how hard, it's, you know, there's so much going on here that it depends on what factors are at play and what jurisdiction you're in. And I guess the policy language too. I believe this is another poll question, or maybe, sorry, this isn't. Fact or fiction on the made whole doctrine. Does it require reimbursement of the deductible? It depends on the case. It doesn't necessarily mean that the insured is entitled to 100% of the deductible, because that's part of what the policy requires. So whether you're including this in the amount to be made whole, usually not. You're going to want to make sure, though, on the state at issue and see whether that should be included. In a typical automobile subrogation claim, usually, you know, the deductible you're talking about is pretty modest, for, you know, 500, 1,000. So this isn't usually perhaps much of an issue. Maybe it is in a larger commercial or umbrella policy, but I guess the point is it shouldn't always be factored in when you're talking about the made whole doctrine. Whether out of a recovery the deductible needs to be reimbursed first or last or at all, it depends again on the state. There are a bunch of states that have either case, statute, or administrative code law. I put in there our chart on it because that's way better than me going through these nuanced statutes and administrative rules. But the overarching point, you're going to want to look to the state you're talking about to determine whether the deductible needs to be reimbursed. And I put some of the more notable ones in because we get, oops, sorry about that. We get a few more questions on them. In California, and it's in the code right there, 2695.7. But it actually has in there that as a matter of course, the demands to the other inside must include reimbursement of the deductible. And you also have to, under California law, for what it's worth, provide certain notice to your insured on what you're up to, that you're subrogating, and that the deductible will be a part of it. In New York, this is another one where they have a regulation in place. You see it right there. After you get a recovery, you're going to do a deductible within 30 days of the recovery. It's a pro rata determination, so you're going to compare the total recovery to the amount paid by the insurer to determine what amount of the deductible needs to be reimbursed. In Texas, you see there again a little, it's a matter of procedure, and you kind of got to know about some timelines. You have to quote unquote take action to recover the deductible within 1 year or 90 days before the limitations period. If you don't do that, you got to pay back the deductible to the insured. So again, these are creatures of statute or administrative code that you want to be aware of after you get your recovery. So I guess again, the point here is at every one of these steps, you know, how to go about what rights do we have, how to go about prosecuting those rights. Okay, now we got a check and we got a recovery in hand. We pursued our subrogation interest. How does that need to be divvied up? Again, these are jurisdictional specific questions where there's a lot of moving parts at play, and you need to be aware of these regulations to make sure things are being done correctly. The other thing, and I think this is, I'll spend a little bit more time on this because I think it's important and sometimes gets overlooked because there's just so much going on that sometimes the most fundamental questions get overlooked. But you want to pay attention to what is the negligence standard in the jurisdiction you're going into. There are some states where you have pure contributory negligence, where if the insured is even 1% at fault, like North Carolina, they can't recover. And the same would be true for a subrogation interest. If a subrogated insurer is stepping into the shoes of the claimant, there's even 1% of contributory fault, that's going to be a total bar to recovery. In other jurisdictions, Arizona, Louisiana, Mississippi, they're on there, Washington, the exact opposite is true. So if the plaintiff is even 99% at fault, mostly at fault, they can still recover, but their damages are reduced. Now, practically speaking, why this is important, in my mind, it comes up is because you're looking at the damages involved in the claim. So in a state like Washington, the plaintiff could be over 50% at fault. Well, Washington's a bad one because they have other. In Rhode Island, if the plaintiff recovers and is even 99% at fault, in a lot of situations, that means there's someone else who likely has a claim, maybe for property damage or maybe for personal injury, what have you. So pursuing subrogation, you know, there's more to be discussed in those jurisdictions because there's perhaps a counterclaim that could be asserted. But when is it perhaps cost effective to do so? The damages involved. If one side of the equation, although they were mostly at fault for the accident, has, you know, 3 times as much damage, maybe they broke something, or maybe it's a difference in the type of vehicle involved. You know, then even though one side is more at fault than the other, the net recovery will still be a gain because the damages are lopsided. So those are things we want to think about depending on what the fault scheme is. So you have the pure contributory, pure comparative, and then I'd say a vast majority of states fall within a modified version of the two. So if the plaintiff can't recover in a 50% bar state, the plaintiff can't recover if they're 50% at fault or more. So you need to show that they're 49% at fault. Oklahoma, Nebraska, and I have them listed there. 51% fault, kind of the same thing, except you have to be, you can't be more at fault than the other side. So that's where you can be 50% at fault. You can be just as wrong as the other side, but you can't be 51%. And there's a lot of states that follow that rule as well, and I have them listed there. Another thing to be aware of by the jurisdiction is something called the sudden emergency doctrine. And I have it listed out there. You're not liable if it's a reasonable response for the sudden emergency, usually if the person did not involve the emergency. These cases can be tough for a lot of different reasons. And the main one I'm thinking of is at the very bottom, the medical emergency one. If the driver had a seizure or some sort of medical condition that incapacitates them either completely or momentarily, and that in that moment of incapacitation, the accident happens, is that a sudden emergency? It depends on the jurisdiction. You're going to want to look towards what the prongs are. And when you're talking about a medical emergency, I think that last part of the general definition I gave at the top is very important, so long as the person did not create the emergency. When you're talking about a medical emergency, some of the things I just went through, was there prior notice of the medical condition, a history of, throwing hypotheticals out there, seizures or some other medical condition that, it was somewhat foreseeable that this type of incapacitation could happen. So you want to look towards the nature of the accident, and then maybe, there's going to maybe need to be some investigation as to what came before the accident to see if it truly is a sudden emergency. And situationally, the other one it mainly comes up is weather, act of God, something like that. But again, it can't be something that you created, that the adverse party created or lent a hand to. So if the defense is sudden emergency, the roads were basically a skating rink, no one could drive out there. Well, you want to look at the weather. You want to get the historic weather data. You want to get maybe some witness accounting, what the investigating officer said. If it's been like that for quite some time, then perhaps the simple act of operating a vehicle or at a certain speed is creating the emergency by itself, because the defendant had notice of what the conditions were like before they got into that situation. So this is some of the investigation that needs to happen when you have this sudden emergency defense, and it can impact the amount of recovery due, but again, sometimes it warrants more investigation is really the tip off. Excuse me. The other defense that's pretty common is a seatbelt defense. So defendant driver, tortfeasor driver, I guess, gets into an accident with the claimant insured. Can he or she say, well, the claimant insured wasn't wearing their seatbelt? They wouldn't have been damaged or wouldn't have been damaged to the same extent had they been wearing their seatbelt. I just put the states in there, same thing we've been going through. There's some states where there is no seatbelt defense. The defendant can't use it, as a matter of statute, anything like that. There's other states where it's a very appropriate question and can be included. And I list those out as well. So whether the whether the tortfeasor can raise a hand and say, well, the claimant wasn't wearing a seatbelt, so I shouldn't be liable for those benefits or liable for those damages, depends on the jurisdiction you're in. How it's usually applied, it can be applied in the traditional sense that we think of comparative fault with. So if there's an accident on the road, and let's just say tortfeasor rear ends the passenger, and when it comes to the ensuing damages, maybe there's going to be some fault on the insured by way of comparative negligence. Say, yeah, well, running into him from the back, him or her from the back was 85% or 80% of it, but not wearing a seatbelt was also 20% negligent. So sometimes it's that theory. The other theory, and this is less commonplace, but in New York, it falls under a failure to mitigate damages. So in tort, generally speaking, there's an obligation of the victim or the aggrieved party. After you get injured, you can't You got to take steps to make sure your damages aren't, beyond the scope of the event at issue, or you can't just make them so big without any care of whether they're reasonable and related. And so in some, when you're talking about seatbelts, sometimes it falls under that theory that by not wearing it, there's a failure to mitigate the damages. So if you were wearing your seatbelt, in my rear end accident, you may have only been, thrust forward a little bit and had some minor whiplash, but you weren't, and you went forward into the steering wheel and maybe broke your wrist. So it's you see this under a failure to mitigate theory. Some limit the percentage by statute. The statute I'll go over because it's in my home neck of the woods, and there are a lot of states that do it. Is they put a statutory cap on there, so that's section 895.045. That's a Wisconsin statute. What it does is it arms the jury with the ability to take into account the seatbelt defense. They don't have to buy it, but they can. And if they do, it caps how much fault they can ascribe to it. So in Wisconsin, it's 15%. So again, if you see the seatbelt defense, the question that should be popping off in your head is, what does this jurisdiction allow by way of the defense, and how is it best approached? Comparative fault, jury finding, etc. Another good question to ask, and another moving part in all these equations, is accidents. Sometimes they're very straightforward. They're Joe driver got hit by Terry tortfeasor, and it's just one driver who owns the vehicle who got hit by another driver who owns his or her vehicle. That is not always the case, as we all know. Sometimes you're driving a vehicle that belongs to someone else, or that's been given to someone else. So the Bailment theory of recovery, I think, is a very good tool and perhaps underutilized in the subrogation world, because you're talking about when you give a car to someone else, a dealership, repair shop, a valet attendant, something like that, and it comes back and it's been damaged. Maybe it was in an accident, maybe it was in a fire or something like that, like we talked about before on the garage keepers policy. What's the standard? Do you have to show that that damage was caused by the negligence of the bailee or person in possession of the borrowed vehicle? In some states, you don't need to, because there's a presumption. If I give you something and it's perfectly fine, you need to give it back to me in the same condition as which you received it. And this is especially the case depending on the reason you gave it to the other person. If the other person or entity received the vehicle as part of a proprietary or profit, or is motivated by profit, a lot of states have this presumption of negligence. Hey, we gave you this vehicle, we expected it back in the same condition. Because you were doing it because the reason you had it was for profit or business purposes, you have this obligation of returning it in that same condition. The salient point here is that you don't need to, you either don't need to prove negligence in the same sense, or you have a presumption of negligence right off the bat. So instead of you having to show a duty and causation and all that, or proximate cause and all that, all you have to show is you gave the vehicle in that condition and it didn't come back in that condition. Then it's on the person, the bailee with the vehicle, to come back and say, no, it wasn't anything we did. Maybe, they'll assert a sudden emergency, act of God, something like that, but they have the burden of proof and persuasion that they were not negligent. They were not negligent in allowing that damage to happen. In some other cases, simply showing that the vehicle, in other jurisdictions, simply showing that it was stolen or destroyed in like a fire, that's typically what we're talking about in Bailey. That's not enough. You still have to show negligence. You still have to show, perhaps if it was in a fire, what was the cause of that fire and who's responsible for it. Or if it's stolen, maybe you have to show negligence in a pattern of crimes or lack of security equipment or lack of industrial practices that are commonplace to make sure vehicles are safe and secure and whatever else is required. So in some jurisdictions, you do still have to go down the traditional negligence gauntlet, but in most jurisdictions, when you have this type of fact pattern, maybe you want to be thinking, oh, is there another avenue of recovery that is easier and more cost effective than your traditional negligence, tort recovery. And another, I guess, similar issue but different is negligent entrustment. So when you give your vehicle to someone else and say, hey, here you go, you can drive it, are you liable for the driver's negligence, their inexperience, their recklessness, a history of incompetency? These are all good questions. Or it could deal with the vehicle itself. If you had issues with your brakes, a normal driver, and you knew about it, lights are going off in the vehicle, you're hearing a sound, maybe you can hear the grinding on the drum pad, something like that. And then you entrust that vehicle to someone else, and suddenly the brakes fail, causing an injury, causing a rear end accident. Who's ultimately liable there? And this is one where it could very well be the owner, and maybe partially or not at all the driver, depending on what he or she knew. But this is where investigation is important, and the cause of loss and what facts are out there. Because if you entrusted a vehicle to another and you knew there was an issue with the brakes, it could very well be the case that the owner is going to be on the hook either partially or fully for that loss. There can be a combination of both the driver and owner are liable for the loss. In some jurisdictions, if you plead this, if you have a negligent entrustment claim, what that allows you to do is bring in some of this evidence that I was talking about before. Let's just say, as opposed to my brake pad example, the driver you entrusted your vehicle with had a few DUIs or something on his record or her record. If you entrusted it to him or her and they get in an accident, is that negligent entrustment if you knew about their driving history? So by pleading it, what it allows you to do in some jurisdictions is open the gambit of evidence you can put forward, and in some cases put in the driving record to show that, yeah, there's been a history. This driver wasn't just reckless or incompetent or inexperienced here. They have been for quite some time, and we can show it objectively through a driving record or witness testimony, vehicle service reports, what have you. So it's important to know. I wanted to leave enough time for questions, and it looks like we'll be fine here, I think. The other thing you want to be thinking about when you're talking about negligent entrustment is, and it's often referred to as the family purpose doctrine, but the question is, who is the vehicle being entrusted to? If it was a family member of the owner, and there's usually a residency requirement that they live in the same abode or something like that, then the owner can be liable for damages caused by the family member, or they cannot be, depending on the jurisdiction. And I have them down here, a couple of them down there, on whether it's applicable or not. And I'll give you a case-specific example. Illinois, for example, does recognize somewhat the family purpose doctrine, but that second question is more pertinent. In Illinois, you need to be, I think you need to show something other than its general use or convenience of the family. You need to show that it's for the benefit of the owner involved the actual trip was. So these standards depend on the jurisdiction you're in, and what questions you need to be asking at the onset. Because if it does apply, the targets for recovery, the amount of recovery, it can change a lot. And on that same note, what insurance policy you're going after. All of this is good to know right off the bat to properly evaluate recovery potential. The last, there's a couple of last things. I'm going to go very quickly. The economic loss doctrine, it's usually not as applicable in an automobile kind of situation, but basically what it says is parties to a contract can't get damages outside of what's covered by that contract. That's the very simplistic form of economic loss doctrine. It's actually a very complex, legally speaking, very complex doctrine, usually in the property damage context. But I guess the takeaway here is you want to look to damages. Are you talking about damages directly at issue? So if it's, let's say, a product liability case and you're going after the manufacturer, are you talking about, let's say, a product caused a fire, caused an engine fire, and the engine fire caused a house to burn down? You know, something like that. We have an auto policy, and it's mixed like that with the manufacturer. Perhaps maybe in some jurisdictions there's a limitation on the amount of damages you can go after for the car, but not the damages to the other, you know, consequential, I'm calling it here, economic losses. But it's something that can be at issue, but usually isn't in auto. But for the right fact pattern, especially when you have some of these mixed damages, it's something to think of. And I have it down there, damage to the property other than the product, and that was what I was trying to get at with fire in a house. You know, the fire originated in the vehicle, maybe because of a manufacturing issue, but the damage is the property outside of the vehicle, like a house, something like that. Usually requires a consumer transaction. Can also be involved in service contracts and, you know, garagemen, tort claims against the garage for negligent repair, stuff like that. You know, maybe something they did affected a fuel line and allowed the fire to occur. So we have a chart on this, the economic loss doctrine, and in fact, we have a lot of charts on some very good, a lot of the stuff we went through, Common Fund, Made Whole, economic loss. They're very good resources. I use them on a daily basis. All of my colleagues do, actually. I won't even say most because I think we all have them bookmarked. Last thing, and I'll go very quickly here. Choice of law, again, maybe not as much of an inquiry here in auto as it is maybe in property and work comp, but something to be aware of, especially in certain jurisdictions, New York and New Jersey. And like Michigan, no fault is one of the exceptions to tort is an out-of-state accident. So you can play Michigan benefits. If the accident happened in Wisconsin, you can still get tort recovery for those benefits, as opposed to a purely intrastate Michigan accident. Perhaps that's not the case. But there are certain cases where you do want to look to choice of law as to what benefits are paid. And this is the real choice of law. The two jurisdictions you're looking at are the state where the policy was issued primarily and where the accident occurred, and deciding, you know, which laws are going to govern your subrogation and reimbursement rights. And so I have Wisconsin in there as an example. Wisconsin does allow medical payment subrogation for the driver involved in the accident. In California, you don't have that. So if you have, you know, an out-of-state driver involved in one of these jurisdictions, maybe you do want to think about some of these choice of law questions. Dram shop, another one, can be at issue. You're talking about going after a bar or establishment for over-serving. The dram shop, I'll just leave it as it's largely driven by statute. And there are certain things that maybe give rise to a dram shop claim pretty clearly, like service to a minor. And most states find that a bar or establishment is going to be liable if you serve a minor and then that minor goes out and gets in an accident. Why? Because of the public policy. Really, two public policies: not over serving and not serving people who are underage. So that's dram shop. So that was, like I said, a very quick overview of a lot of different topics. And now I'll go through some questions that I have. One question I have is, how could the statutory subro override the policy subro? That's a great question. Michigan is a case where I'm thinking of it. And in fact, Michigan is maybe a better example because of their 19 and 20 rule changes. It used to be the case before 2019 that if you had a policy issued out of state and you outside of the state of Michigan, but the insurer was certified to write policies within the state of Michigan. So generally speaking, they can, but for this particular claim, the policy was issued outside of Michigan. When a person was injured in Michigan, that policy, that out-of-state policy, would get rewritten. So that's an example of where the statutory subro would override the policy language. Another area is made whole doctrine. In some states, the policy language can overcome made whole. In other states, the statutory requirement is going to negate whatever policy language you have saying, usually it's, we're entitled to first right of recovery regardless of whether the insured is fully compensated or made whole for the accident. That language and its effect on the recovery may depend on the statute, and in certain states you can't override made whole depending on the statute. Can you briefly touch upon the new House bill on Florida State? I would love to, and that's a great question. It's more, there's more at play than I can do justice for in 10 minutes, but what I can say is like I said, MWL just did this this webinar about 2 weeks ago, and I tell you what, I'll get your information, and when it goes live on our system, which I think is going to be very shortly, I'll shoot you a link with that, and it'll go into much better depth. It's the recording of a past webinar from 2 weeks ago. Much better depth and answer questions. Can we send the slide deck? I'd be happy to. I can do that as well. There's one question here, self-insured, I'm not sure on that. One question about I'm not sure about what the question is asking on the self-insured ERISA plans. I'll email you about that one. Yeah, this is a good question about in states where made whole is applicable, does it need to be determined by a judge before it can, to determine the subrogation right? This is actually something that happens in Wisconsin too. Yeah, that can often be the case, that if there's a contest between the insured who got a recovery and the insurer as to whether the made whole doctrine applies, there can be an evidentiary hearing. In Wisconsin, it's commonly referred to as a Rhines hearing. But some sort of almost mini trial, in fact, it is a mini trial in Wisconsin where you write briefs, you bring witness testimony, you do what you can, and both sides try to prove whether or not an insured was made whole, and in turn what recovery rights exist. So yeah, that can be the case. There's a question here about non-contributory work. I'll have to email you about that. I'm not sure. Not sure if I understand it, but I'll email you about that one. There's a question here about the self-insured collision in Michigan. This is a great one, and in fact, Michigan there are points of Michigan, just simple one-off points, mini tort being one of them, that could each be their own hour-long presentation or more so. It is so convoluted, it's so messy. But to answer your question, self-insured for a collision where there is no deductible, can you collect the $3,000? My take on it is yes. And we get this question, I get this question actually a few times. So it might, it must be something that's on people's mind. But my take on it is yes. The reason why I think that is like I said, Michigan mini tort says to the extent losses are not covered by insurance. Well, if you're self-insured, the question is it covered by insurance? To be self-insured, you have to have a certificate with the Department of Insurance and with the Secretary of State, I believe, actually, in Michigan to get that self-insured status. Collision coverage is not mandated by Michigan no fault. When you talk about the PIP benefits, the medical and wage loss, those are mandated. And now to a certain extent, to a certain cap, it used to be unlimited medical and then 3 years of wage loss. Now medical can be tiered, but those are mandatory. Collision coverage is not mandatory. It's an optionary form of coverage. So my take on it is, although they're self-insured, they don't have this optionary collision coverage. They're self-insured for mandatory no-fault coverage, and therefore no fault, or excuse me, mini tort for the what would otherwise be the deductible is perfectly fine. There's a question here. I think DV is diminution in value can only be recovered if it was paid under a collision, correct? Let me think about it. I think for the most part, that is correct. I guess it could be maybe, yeah, I think in large part that's a correct statement. I'm trying to think of when the reason I say that is I don't know what other line of coverage diminution of value would be paid under when you're seeking subrogation for it. So I think that's a correct statement. There's one here, hidden damages. I'll have to email you about that. Again, a copy of the slides. I'll send those out. There's another one in here in state that requires insured be made whole. Does that include diminution of value if the insured is filing? That's a great question. They're all great questions, but that's a great question too. Because it's again, it's very jurisdictional. And if you're in a state that's comparing the element of damages at issue, then maybe it should be, maybe it shouldn't be considered. In other states, it definitely could be. There's a question here about Washington and UIM. I'll answer that separately just because Washington's perhaps one of the more tricky states, and the landscape of Washington law, I think we actually did an article on it quite recently on the Davies decision, is changing, especially in the context of made whole. Here's a question. When you say some information depends on the policy language, is that the policy for the person seeking recovery or our policy? That's a great question too. Usually I'm talking about the policy issued to your insured, the person you're paying, person or entity you're paying benefits to. You're looking at that policy language. The other policy language the policy language of the adverse driver can be something that's very pertinent to recovery. It's not, I'm talking about probably a minority of jurisdictions. Michigan, again, is one of them that I'm thinking of because it's that complicated of a state. But Michigan, for example, when you do these tiered, when you choose your coverage, okay, I want coverage at, they have different intervals, 50, 100,000, 250. There's different intervals in the statute. There's some comparing and contrasting to the liability insurer of the other driver for what can be recovered in tort. So to answer your question, primarily we're looking to the first party policy where you pay benefits to your own insured to see if it has that disclaiming made whole, common fund, etc., right of subrogation. But the other policy can be pertinent too, depending on what's at play. Does ERISA kicks several laws out on auto in most, if not all states? Yes, I guess is a very, very general answer, but do not run with it. ERISA is very specialized. ERISA rights are usually very good because they're established by ERISA and a federal statute for employee benefits. But in large part, I'd say the answer is yes. ERISA, depends if it's a self-funded plan or not self-funded too. That's a very big question that needs to be asked. So I guess I'll say yes with the caveat that you're talking about a self-funded plan. And I'm talking generally that it would in all states. It usually preempts doctrines that go against subrogation. I'm talking about made whole, I guess. But ERISA is its own animal, and you need to be asking certain questions with ERISA that I'm not going to be able to do here. We do have ERISA webinars up there as well, and in fact, we've done a couple of those this year too that are great for taking a look at. Cheat sheet for all states. And I'll end on this. I'll get to all the other questions. Sorry, like I said, I want to respect everyone's time and end on time, and I see it's 11:59. Cheat sheets for all states. Great question. Go to MWL.com and go to our resources. And the two things you'll see is a map of all the 50 states, and you'll see resources, there's charts. And the charts are even organized by automobile, work comp, etc. There we have charts on things that I go in there and I'm like, wow, we have a chart on that. These charts are useful. And I really do mean it. Me, my colleagues, I use them on a daily basis. I have them bookmarked in my tabs. They're the cheat sheets for all the states. They're a good running point. They're exactly what they are. They're published at the time they're published. Laws, case law, statutes, administrative codes are being changed every day. So we try to keep them current. We're always, sometimes a third party tells them, hey, take a look at this one, or we all have, we're keeping an eye on a lot of these cases and statutes, so we change them ourselves. But long and short, our charts are a great resource. They are a great cheat sheet to at least get started on whatever issue you have. There's one on common fund, there's one on made whole, there's one on auto in general to see the comparative fault scheme and all that. So they're great. There's a lot more questions here. And again, I'll email people one by one on those. And I want to thank everyone for attending. I hope this was helpful. We're going to take a look at what people put in the chat section for the next state we're going to do, and we'll announce that shortly here. Again, my information is all up there. There's my email, there's our website. Please feel free to email me with any other questions you have. I hope this is useful, and I hope people come back for the next one we're going to do on the particular states we choose. So thanks again, everyone. I hope you have a great rest of your day, and I hope this was helpful.